SJC-12235, Commonwealth v. George T. Rhodes.
Mr. Keneally, before you start, our condolences on the loss of your father.
Thank you, Your Honors. And I'd like to also start by thanking the court for allowing me to reschedule this argument. And I apologize for any inconvenience that it may have caused.
You don't need to apologize for attending the wake for your father, so
Thank you.
you may proceed.
May it please the court, Your Honors. Joseph Keneally for Mr. Rhodes. The principal basis, Your Honors, for the defendant's appeal is his position that his trial attorney rendered ineffective assistance of counsel by failing to request an instruction of voluntary manslaughter.
What do we do with Judge Chin's finding of not crediting counsel as to whether it was inadvertent or not?
Well, Your Honor, I believe that this court can interpret the affidavit to the extent that it needs to. He did not hear evidence. He did not have call him as a witness.
But he was the trial judge.
He was the trial judge, and counsel stated, in fact, that this was inadvertent. He didn't credit that, but I think that this court has the opportunity to review that, at least for an abuse of discretion. I think in this case, I don't know what else trial counsel needed to say other than the fact that this was something that he missed. He stated that. I think that would have been sufficient. The fact that the judge the judge did not accept that, I would submit as something that can be reviewed by this court for an abuse of discretion. I think that that's what that is in this case. I think the involuntary manslaughter instruction in this case was warranted by the evidence. It was wholly consistent with the defendant's...
I'm sorry, voluntary or involuntary?
Voluntary manslaughter.
Voluntary.
Trial counsel requested an involuntary manslaughter instruction. The argument here is that he should have, in addition, or perhaps in lieu of, requested a voluntary manslaughter
Do you
instruction.
think the two would have been, would have canceled each other? You know, do you think you couldn't have had one? You had to have had one or the other, but not both?
No, but I don't think that's the case at all. I think that all three of these theories of defense would be entirely consistent with each other. Counsel could have argued that in a heat of passion, based on reasonable provocation, the defendant struck out against the victim in this case, inflicting the head injuries, rendering her unconscious, and thereafter did not take any steps to contact anyone to get help for her. And in addition to that, could also have stated that despite the injuries inflicted, if that was in fact the case, if the jury had found that he inflicted the injuries, that the injuries nonetheless were not the cause of the...
Where was the evidence that it was a consensual sex act that took him by surprise?
Well, I think one of the things that you can do is you can look at the jury's... Well, to back up a little bit, Justice Gaziano, I think that what you have to do is bear in mind that we're talking about viewing this case in light most favorable to the defendant.
He didn't testify.
He did not testify.
Okay, so I'm just looking at the factual basis a judge would have had to say that there was this provocation as opposed to the Commonwealth theory.
Well, right, the Commonwealth theory, in fact, was
Right, well,
that...
put the Commonwealth theory aside, right? So, but I just looking, all right, so you're the trial lawyer.
Yes.
And you're an effective trial lawyer, and you're arguing to the judge for a voluntary manslaughter based on provocation.
Yes.
What facts do you say support the inference that it was a consensual sex act that took him by surprise, leading to the heat of passion? Exactly.
Well, the first thing you could do, I would imagine, is evaluate the circumstances leading up to their approach and entrance to the garage bay. By all accounts, the victim left her house at 9 o'clock, met up with the defendant shortly thereafter, and the two spent at least a couple hours walking around the streets of Brockton, mostly the Main Street area of Brockton. The video surveillance indicated that at one point the two of them were walking perhaps even arm in arm, and that the defendant was carrying the victim's bag with them as they walked. There was no indication that, in fact, the victim was being dragged into the bay, that she entered it involuntarily, and in fact, there was evidence, I believe there's forensic evidence, I don't have the transcript cite, but there was forensic evidence introduced at trial that the defendant at some point may have performed oral sex on the victim. meaning that a vaginal swab was taken of the victim with the defendant's saliva on it. Now, it seems entirely likely, given the fact that the victim was found without any clothes on from the waist down, that that possibly could have happened in the garage bay. Given that, and given that there's no way to parse out whether these injuries were inflicted before the bite or after the bite. But despite that, like I suggested, in viewing the evidence in light most favorable to the defendant, one can surmise that consensual sexual activity took place in the garage bay.
In my memory, was the saliva tested for DNA?
I believe a swab was tested, and the defendant's DNA, I'm fairly sure it was saliva, was found on that swab.
Okay, as to provocation, how do you establish sufficient to get us an instruction, the subjective part of that?
Well, one of the things, Your Honor, generally, in most of these cases, you have a defendant testifying. Basically, Commonwealth versus Sear is a good example. Commonwealth versus Felix, which is a couple of years ago, are both cases where the defendant actually testified and said, here's how I felt when these events were unfolding. That doesn't necessarily, I would submit, suggest that you have to have a defendant's testimony.
You could have the Commonwealth. There are cases where the Commonwealth, for whatever reason, because they want some parts of it, puts a defendant's statement in.
Yeah.
Where they give you, so he doesn't necessarily have to testify.
Right.
But you still need evidence.
Right. I believe in Commonwealth versus Berry was a case where the defendant did not want a voluntary manslaughter instruction, and what happened was that it was given to him over his objection, and I believe, I'm not 100% sure, but it seemed like from this court's decision that what was going on was the court looked at the circumstances of the homicide, meaning eyewitness testimony as to what exactly happened, because he said he didn't do it in Berry's case.
So in this case, what gives you the subjective component?
Well, what you can do is look at the circumstances of the homicide. Commonwealth versus Pitts, 403 Mass 665, at page 668, the court suggested that in determining the subjective state of mind of a defendant, it can look at the circumstances of the homicide, perhaps in light of any testimony. And I think you can look at these circumstances and say that these two people walked in. This was 10 minutes that this event unfolded, okay? And that given the injuries inflicted, it looked like it's something that happened in rapid succession. It looks like it's something that wasn't planned. She was not lured in. There's no preconceived hostilities between the two, or pre-existing hostilities between the two, and that the attack, when it occurred, happened fairly quickly and rapidly. And I would think that those circumstances would speak a subjective state of provocation and hostility.
But don't you have his discussion with his friend, the fellow he roomed with, I forget his name?
Willie Watson, Your Honor.
Watson?
Mr. Watson, yes.
So I'm looking to 3B, page 116. When Watson is describing what the defendant told him, who said he was with a girl and that she was giving him a blowjob and she bit his privates. Later, he said when she bit him, she had blood in her mouth and she passed out. Then later, what did you say? I said, so if she bit you hard, he said that she bit him hard. So you have him saying that she bit him hard and that it yielded blood. And also he describes it as a blowjob, which I would think would be, we usually think it to be consensual. Do you agree that if you were to, if there were to be such an instruction, would the jury not need to be told that if they were to find that indeed this was not consensual, that it would not be a reasonable provocation for somebody fighting off, somebody forcing someone to do a blowjob to bite the penis? I mean, it would be.
I think if that were part and parcel with the voluntary manslaughter instruction, that the Commonwealth could certainly argue that instruction should be included as an adjunct. But in terms of whether or not an instruction should have been given at all in this case, this was a witness who testified for the government, and this is a witness who testified as to what he believes the defendant said.
Is Watson.
Yes.
Right.
And if we were to look at the issue here as to whether or not an instruction should have been given at all, the judge would necessarily have to have to consider the fact that the jury might reject Watson's claim altogether. Now, Willie Watson was a person who, for good or for ill, decided to house Mr. Rhodes after this event took place, and his house was searched as a result of the investigation. It didn't seem like it would be unreasonable to suggest that he wanted nothing to do with this situation and didn't probably harbor too much sympathy for Mr. Rhodes. So given that, I think the jury could have concluded it's possible, particularly when looking at the evidence in light most favorable to the defendant, that they could discount what Mr. Watson attributed to Mr. Rhodes in its entirety. So the fact...
But they could also credit it.
But right, of course they could, in determining whether or not he was guilty, but not...
My question's different.
Okay.
My question is, if you were to have gotten a voluntary manslaughter instruction,
Yes.
would there also need to be an instruction that said, if you were to find that indeed he forced himself upon her and that this was indeed rape, that the victim's act of self-defense to bite the penis is not going to be, may not be used as reasonable provocation for the killing? That you can't basically rape somebody and then when they fight back, say, aha, that was the provocation that allowed me, that caused me to kill her.
I think that's probably fair, Your Honor. I think that if one were to suggest that enlisting self-defense, that the use of defending oneself cannot lead someone to be reasonably provoked, I think that's fair. I think the Commonwealth would have been within its rights to request that instruction. However, I would note that in this case, it looks like for all the world, the jury rejected the notion that forced sex took place in this case.
Well, they rejected the notion that the Commonwealth had proven it beyond a reasonable doubt.
That's true.
Actually, they didn't even do that. They didn't reach it, did they? It was not
Well,
he was found guilty on 2 of the 3 theories. We don't know whether 6 or 8 of the jurors would have found him guilty on the 3rd theory, but they didn't.
Right, he was found not guilty of felony murder.
Was he found not guilty of felony murder, or was he, I mean, I went back to the verdict, and it said, you know, do you find him guilty? Yes, on what theory? And they said those 2, but
That's an interesting point, Your Honor.
That's different from a
frankly,
finding of
I
not guilty. It's a finding that they were unanimous as to 2 of the 3 theories, and we don't know whether or not it was a finding of not guilty or simply, but they didn't find him guilty on that 3rd theory.
Right.
That's all we know.
Right. I honestly didn't consider that, Your Honor, but I would think that the fact that they did not come back with a guilty, given the presumption of innocence, we would assume that, in fact, that's where that verdict lies.
And I gather there was a separate charge of armed robbery, but no separate charge of aggravated rape.
Yes.
So
In
the
fact, during the pretrial, the motions in limine, there was some discussion by trial counsel as whether or not the Commonwealth could go forward with an aggravated rape as a predicate felony for the felony murder, given the fact that there was no independent charge of that, and the judge let it go forward nonetheless. So,
You brought up Commonwealth versus Felix, and also I have in mind Justice Budd's decision in Commonwealth versus Gula. Let's say for the purpose of this question that in the light most favorable to the defendant, there was reasonable provocation. What do you do with the response, and whether the response was so disproportionate to the provocation? Here you have taken the evidence in the light most favorable to the defendant. At least 3 times the defendant took the victim's head and banged it against the concrete floor. If you look at Commonwealth versus Felix, where Justice Botsford says it would have been prudent to give a voluntary manslaughter instruction, but in light most favorable to the defendant wasn't entitled to it. Why wouldn't this case be Commonwealth versus Felix?
well, for a couple of reasons, Your Honor. I mean, Garabedian's kind of like that too, where a scratch was found not to have warranted a response, or Rimbazuski, I'm sorry, warranted a response like that. I think that this was a fairly chaotic scene in the garage bay, particularly given 2 separate injuries that were independent of each other. I would suggest that the exact, the precise level of the extent of the attack is not quite as clear as it is in those cases. I think that the injury sustained by the defendant is more significant in this case than it was in Felix, whereas I think there was even some question as to whether or not she threw a punch or actually landed a punch on her husband, which prompted this. And I would think that given the extent of the injury to Mr. Rhodes, I mean, he lost a dime-sized chunk of his body and was clearly bleeding profusely based on the blood that was found at the scene. I would suggest that, given that, and given the sort of murky nature as to how many blows were struck,
Remind me, though, I thought that the evidence was at least 3.
it was at least 3. I think someone said up to 5, but I'm not sure exactly if any of the experts could say definitely one way or the other. I mean, 3 is a fair bet, but I would suggest that given the injury sustained by Mr. Rhodes and given the reaction, I think this is a much closer case than Felix, and certainly much closer case than Rimaszewski. One of the things that I would point out, Your Honors, is that this wasn't simply, in the context of prejudice, if this court finds that this was an error, it should consider the fact that given that the jury clearly wasn't 100% sold on the rape murder concept, you know, and given the fact that there was a lot of evidence that these two were behaving in a friendly fashion throughout the day, the jury had to be wondering at some point, what if this wasn't a sexual assault, then what would have led to this violent outburst? And I think that the response to that would be obvious. It would be these two people were, if they, in fact they did find they were engaging in consensual sexual activity, then the outburst would be prompted by this injury sustained to the defendant, by the victim, whether it was inadvertent or otherwise. And as a result of that, they could have found that he reacted violently and in a fit of anger or something along those lines. And that's precisely what voluntary manslaughter is. I think if you look at the cases like Commonwealth versus Barry and Commonwealth versus Sear and Commonwealth versus Kendrick, it's a 1966 case where an individual hit the defendant with a fire poker or something along those lines, and he reacted and killed the individual. We have a very similar situation where an injury sustained to the defendant by the victim provokes a deadly response. And that's not to say necessarily that we know for certain that the jury would have come back with this, but I think it's certainly plausible.
I guess if I could use one word for what I'm asking you, I'm saying disproportionate. Is the response disproportionate to the provocation with, in light most favorable to the defendant, 3 bangs of the head against the concrete floor?
I think given the distinct possibility that alcohol was involved, I think given the extent that the defendant's injury was largely glossed over, we never quite knew how bad it was, other than that an excessive amount of blood fell as a result of this. He never even got medical treatment for this injury. And I don't know if it's disproportionate, Justice Lowy, and I would suggest that every time we have a voluntary manslaughter circumstance, the reaction is to some level disproportionate because we have someone who's alive and someone who's not.
No, I appreciate that. It's
Yeah.
just that certain cases, including Commonwealth versus Felix, without using the word, seem to engage in a disproportionate response to provocation.
I think that's fair. I don't think that that's this case, respectfully. And finally, the last element that I would suggest in terms of if this court were to evaluate it for purposes of prejudice would be to suggest that this was pretty much the best defense theory that would have been available to the defendant. The causation theory, if you read Commonwealth versus Santiago, I don't think there's any plausible way the jury could have found that the defendant played no part in the death of this victim.
Do we have any idea of what the defense lawyer is thinking? I mean, it's sort of weird to me that he says in closing, volume 7, page 76, you would be well warranted in finding that after they engaged in sex, after Mr. Rhodes' penis was bitten, in his anger, he went over to Ms. McLean and smashed her head into the ground.
That's voluntary manslaughter, Your Honor.
No,
Respectfully.
but that's, I mean, it's weird to me that he makes an argument of voluntary manslaughter but never seeks an instruction with
I would
regard to
submit
voluntary
that's what ineffective assistance of counsel, that's what leads to that sort of thing. I mean, he clearly was going there. There's no question he was going there, but he didn't ask for the instruction. And he could argue it, but without the instruction, the jury really couldn't consider that theory, despite the fact that I would submit that if you look at the causation, if you look at the involuntary manslaughter instruction he wanted, which essentially he didn't want to attribute any criminal culpability to the defendant until after he inflicted the injury, which doesn't make any sense, I think this was his best shot. And I believe that under the circumstances, his failure to request it represents ineffective assistance to counsel and warrants a new trial or a reduction of the verdict.
No, I've not seen his affidavit. Does he explain anything in his affidavit as to why he didn't? I know he says claims, I guess, it was inadvertent, but is there any, do we
He
have
did
any
not
more?
explain in his affidavit, and frankly, I'm not quite sure why it happened.
Just one question?
Certainly.
About the closing?
Oh, yes.
Just one question.
Sure.
On the strangulation.
Yes.
Why isn't the petechia and the scratches on the neck enough to argue for the Commonwealth?
If you look at the transcript and the testimony of the expert witnesses, there are two witnesses who testified as to whether or not what this particular hemorrhage represented. Dr. Welton, who's a medical examiner, he basically testified that a possible theoretical cause of petechial hemorrhage would be strangulation. But then he goes on to describe what he believes caused it, which is the blunt force trauma to the head. Dr. La Posada, who is the expert for the defense, she was asked the same thing, whether strangulation could be a cause. She said, in theory, it could be a cause, but essentially said that this happened when this woman got run over by a truck. And
Yeah, but the issue is not what caused the death. The issue is whether on extreme atrocity or cruelty or deliberate premeditation, the jury can consider that some strangulation was involved, not whether or not the Commonwealth could prove the case. There was no strangulation charge. I don't even know if the crime existed at the time.
no, but I would submit that there's not even really any evidence that strangulation took place. The only thing you got from the experts was that it's theoretically possible that it is possible that strangulation could cause petechial hemorrhage.
And scratches on the neck?
There are scratches on her neck, but they're called superficial, and they're only on one side. Now, if the Commonwealth wanted to, they could have dug deeper and said, was there bruising on the neck? Was there any evidence that would indicate that strangulation took place? But they stayed away from it, whether it was by intent or design or inadvertence. They didn't go there. They did not investigate with these experts, including the medical examiner, whether or not strangulation was a factor, whether there's any evidence of it. They took the scratch, they took the petechial hemorrhage, and they used that to buttress it into this argument, which I suggest is improper.
Just to clarify, are you saying that the experts here said that's not what happened here, or that, in theory, that could have happened here?
They were asked if strangulation could be a cause, or I believe Dr. Welton testified that petechial hemorrhage could be the result of strangulation.
But not for this case?
He never said, in this case, this is what happened. And Dr. La Posada also agreed that petechial hemorrhage could be caused by strangulation.
So you're saying those statements by the expert were not enough for the Commonwealth to take that and make an inference that that's what happened?
No, I think it was an improper leap, given the fact that other than a scratch on the neck, which was never even attributed to the defendant, given the fact that his fingernails were scraped and no DNA from the victim was found on his fingernails, I think that's too far a leap, particularly when now you're talking about two different means of committing a murder.
We have that all the time, though, right? That there's strangulation and there's a negative DNA.
Yes, I mean, it's certainly right. I mean, yes,
That's not.
it's not conclusive for sure. But I think it still is a leap, given the fact that there's really no evidence of strangulation. The government could have gone for that if they wanted to. So if there are any other questions,
Okay,
I appreciate your time. Thank you.
Thank you. Ms. Kelly?
Good morning. Kira Kelly on behalf of the Commonwealth. I'm asking the court this morning to affirm the defendant's conviction for murder in the first degree, as well as the denial of his motion for a new trial. The claim of ineffective assistance is not consistent with the record in this case. As Judge Chin found, voluntary manslaughter would have been inconsistent with the defenses, or at least diminish the force.
Can you explain why it would be inconsistent with the defense? Because I was somewhat persuaded by your brother's description of how both could be there at the same time.
Well, the defense in this case was a two-pronged strategy, the first being that the truck killed the victim, and that was the only cause of her death. The secondary defense pursued by the defense was that even if the head injuries contributed to her death, they were not the result of any intentional act by the defendant. And a finding of voluntary manslaughter under any of the theories, including reasonable provocation, which the defense has argued here, does require the finding of an intentional act by the defendant. The record shows, particularly the charge conference in the day prior to the jury being instructed, that trial counsel considered that idea and was asking the court to steer away from any instruction that would require the finding of an intentional battery.
Did he indicate why?
Well, he said because you'd be stuck with the idea. Now, this was in reference to the intentional battery theory of involuntary manslaughter. He asked the judge not to give that because he said you're still stuck with the idea that the defendant must have intended the conduct. He did say that was a result of her death, but I think it's fair to understand that to mean that resulted in her death. And he said, and I don't think there's any evidence of that. That supports the strategy that he put forward, that the defendant did not cause her death, and that even if it was the head injuries, that was not a result of any intentional act.
There was a significant focus on that at the trial, wasn't there, in terms of the expert evidence and the being run over, what was the cause of death?
There was. Cause of death was absolutely a very live issue at this trial. The defense retained a former medical examiner, Dr. Laposada, who testified that the sole cause of death was the injuries to the victim's torso and lower extremity, which it was not in dispute that those injuries were caused by the truck.
So why in God's name then does the defense attorney in his closing argument say you'd be well warranted in finding out that after they engaged in sex, after Mr. Rhodes' penis was bitten in his anger, he went over to Ms. McLean and smashed her head into the ground?
That was the only passing reference throughout this entire trial to anything.
It's a rather significant passing reference. It's basically the characterization of a voluntary manslaughter defense.
I think that needs to be considered in context of his entire argument and in context of the entire trial. He makes that reference sandwiched between the argument that the truck killed her and then the argument that at most he left her there. It wasn't consistent with his trial strategy or any of the evidence he sought to elicit during the case. And I think simply making that reference in closing argument doesn't entitle him to the instruction where it wasn't warranted by the evidence.
So the evidence in the light most favorable to the defendant is that where there is saliva in her vagina, that they had that they had oral sex in which there was cunnilingus that he did upon her, correct?
I don't think that's a necessary inference from the DNA being present.
There's saliva in her vagina, it's his.
Yes, they were together for some time throughout the day. There's no evidence as to when that DNA was transferred onto her or how.
But again, in the light most favorable to the defendant, where her clothes, where she's found with her pants and panties down, correct, or off, I believe.
They were missing from the scene, yes.
Okay, so, but she was found half naked.
Yes.
Okay, so you have that, and then you have him saying that she was giving him a blowjob and she bit him, which the jury could credit, correct?
Yes.
And that there was a substantial amount of blood arising from the bite, correct?
There was.
And that she bit off a, quote, dime-sized chunk taken out of the tip of his penis, which is what the police officer said he observed. Correct? So that would be and that he then, and that at least the defense attorney in his closing argument said that when that happened, that angered him enough that he banged her head against the floor. And and we know that she died as a result of that, or the jury so found. Correct?
I think pursuing that would still diminish the chosen defense strategy in this case. I think the circumstances of the bite are more indicative by far of an involuntary act. Even if there was a voluntary act earlier, consent can be withdrawn at any time. And the nature and the circumstances under which that took place, where we know from his statement to his friend that he was holding her head, we know there are scratches on her neck, we know that the injury is significant. It's not consistent with something that was inflicted unintentionally due to her drunken state as suggested by the defense. It's indicative of self-defense because it was a significant injury to the defendant. And I think the defense counsel recognized that he had to contend with the defendant's entire statement in this case. It wasn't just that the bite was inflicted, it was that she then fell down or passed out. The defendant didn't testify at this trial, but his statement was admitted through the witness, Mr. Watson, that he made these statements that the girl bit him, but then he said multiple times that she then fell down or passed out. And Mr. Watson even asked him, or testified that he asked him, "What did you do?" And made a comment suggesting that he, Mr. Watson, would have responded with anger or violence to this happening. He said the defendant didn't respond to that and just repeated again, "She passed out."
So I'm sorry. No. So you're basically saying we shouldn't cut and sever Mr. Watson's testimony to fit the defendant's now theory.
Well, what I'm saying is I think defense counsel would have recognized at trial that he had to contend with that entire statement, and that likely influenced his strategy.
And the basis of the involuntary manslaughter was that he abandoned her and to let it be run over?
Yes, and trial counsel did enumerate his reasons for requesting that instruction during the charge conference. It was that he knew she was injured, he left her there, he didn't seek help, he didn't attempt to render aid, he didn't call 911. And he was specifically asked by Judge Chin at the charge conference which theories of manslaughter he wanted, voluntary or involuntary, and he explained why he wanted involuntary only. He made that quite clear. He did consider it. I don't think in hindsight, I don't think it was an abuse of discretion for Judge Chin to find that it wasn't an oversight.
And that's what he argued in his closing argument, other than the reference the chief has made that it was involuntary, correct?
He argued that at most that would have been his client's culpability, and he also argued for the jury to find him not guilty based on his defense that it was the truck that was the sole cause of her death.
And then we have the perplexing statement that the chief alluded to in the closing.
Yes, I don't think that statement is supported by any of what counsel did during the trial. And I think his statement that it was an oversight is clearly, it's contradicted by the record, and I don't think in hindsight he can claim that where he was specifically asked the question, what theory do you want? He thought about it, he came back the next day, he had 2 more opportunities to address the court regarding jury instructions.
But isn't this all indicative of perhaps the fact that he was not as effective as he could have been in terms of picking involuntary over voluntary manslaughter? I'm still confused about what the involuntary part of this is. Was the argument that she passed out and her head bounced on the concrete 3 times?
He did cross-examine the medical experts about whether this could have been caused by a fall. He emphasized the victim's level of intoxication that day, suggesting that she could have fallen or
Did he
injured.
argue that in closing argument or anything?
I don't recall specifically if he used the argument that she could have fallen, but he certainly argued to limit his client's culpability to leaving her there injured and not seeking help.
He could have asked for involuntary and voluntary, correct?
Well, it's the Commonwealth's position that the voluntary manslaughter was not warranted by the evidence, particularly.
But that's not my question. You can make that argument. But it is permissible for him to have gotten a voluntary manslaughter instruction and an involuntary manslaughter instruction, correct?
He could have asked for it, certainly. I don't.
Could have, and if the evidence warranted a voluntary manslaughter instruction and an involuntary manslaughter instruction, he would be entitled to both.
Yes, but I don't know, in this case where Judge Chin made the finding that it was not warranted by the evidence, I don't know what his decision would have been if he would have given that instruction, if it was requested prior. Setting aside whether his conduct did rise to the level of ineffective assistance, it's clear in this case that even if it was an error, it would have been unlikely to influence the jury's verdict. And that's one of the propositions that the Felix case does stand for, that where there was other evidence of deliberate premeditation, the voluntary manslaughter instruction, while should have been given in the Felix case, was unlikely to have influenced the jury's decision.
Well, if he had gotten the instruction, and I'm looking at the model homicide instructions, which quotes Commonwealth versus Brooks, if any view of the evidence would permit a verdict of manslaughter rather than murder, a manslaughter charge should be given. But if he had gotten it, he would have gotten the instruction on heat of passion, on reasonable provocation, which would say reasonable provocation does not require physical contact, but physical contact, even a single blow, may amount to reasonable provocation. Whether the contact is sufficient will depend upon whether a reasonable person under similar circumstances would have been provoked to act out of emotion rather than reasoned reflection, and on whether the defendant was in fact so provoked. That's what he would have gotten had he gotten the instruction. Correct?
Yes.
And a reasonable attorney would not have sought that instruction in these circumstances?
I don't think it was manifestly unreasonable when the decision was made, based on the evidence.
Would a reasonable attorney weigh two defenses and pick one sometimes, one not being consistent with the other?
Absolutely, and in this case, he didn't just choose one, he pursued two. He pursued two that were more consistent with one another than the voluntary manslaughter.
Because his argument is it wasn't an intentional act, and this would have forced him to argue, well, if you don't believe me, I'm going to argue now it was an intentional act.
Yes,
but there was
it would have
provocation.
required him asking the jury to consider and to find that there was an intentional act and then find mitigation. His entire defense was geared towards steering the jury away from that finding.
And by saying that he smashed her head into the ground, that they be warranted in finding that he smashed her head into the ground, that's what he argued, that you'd be warranted to find that he smashed her head into the ground. And how can you say that he was pursuing a view that it was not intentional when he told the jury you'd be warranted in finding that he smashed her head into the ground?
That statement, again, I don't think simply arguing that entitled him to the instruction, where it wasn't warranted by the evidence and it wasn't pursued as a defense throughout the trial. And further, because of the overwhelming evidence of deliberate premeditation and extreme atrocity or cruelty in this case, I don't think the defendant has satisfied his burden of showing that better work or a different approach or a different defense would have accomplished something material for the defense in this case. That was Judge Chin's finding, and I don't think he abused his discretion in finding that. Where here, there was not only evidence that she was struck multiple times, but also that she was likely struck from behind, and that actually supports the defendant's full statement that she fell down, that she was already on the ground when he then approached her from behind and struck her head likely into the concrete multiple times. That's overwhelming evidence of premeditation of the time it would have taken her to approach him, a point at which any reasonable provocation, if it were to exist, would have ended. She would no longer be a threat to him if she fell down, if she was on the ground face down. He then formed the intent to move toward her. He formed the intent to grab the back of her head. He formed the intent to kill her when he smashed her head into the concrete several times. She was struck at least 3 times, probably more. She had 3 distinct lacerations to her forehead, but also multiple additional injuries, blunt force injuries to her head. Yes.
Let me ask you this. Let's I know you disagree, but let's assume that the evidence warranted a voluntary manslaughter instruction. And let's assume, since the defendant made the argument, at least with that very important statement in the closing about intentionally, could find, went and intentionally smashed her head, that he could have just gotten the instruction and not argued it in closing and just let the jury consider it. Do you have an argument nonetheless that if the defendant wants to focus on involuntary manslaughter here, and you've got a credible witness who's going to testify that he ran her over, and you've got expert testimony that that caused the death, that it was a reasonable choice for the defendant, maybe not the best choice, maybe the best choice would have been voluntary manslaughter, but we don't require the best, that it was a reasonable choice to decide to argue not guilty and involuntary manslaughter because you had this uncontroverted evidence of running the victim over with the van.
Yes, it was absolutely a reasonable choice when it was made at trial. And I think that goes to the Glover case, where this court found that it's not unreasonable to forego one theory of manslaughter where giving both would diminish the defendant's claim. And that's exactly what Judge Chin found here, that it would have been inconsistent
Yeah,
or...
but I am having that problem that Justice Bud's brought up twice now. I'm having that same problem. I don't see what harm it would do to just not, he did argue it, but not even, let's say not even argue it. But if I know you disagree with the assumption, if the evidence did support voluntary manslaughter, why it would step on the involuntary manslaughter to just request the instruction, and then do even less than he did, not even mention what he did that would have constituted voluntary manslaughter.
Again,
What
because
harm? Why are they irreconcilable?
it would have required the jury to make a finding that he harmed her intentionally, that it was an intentional act of the defendant that caused her head injuries. And that was inconsistent, or it would diminish his claim that she was injured some other way and he just left her there, or that they were there together and the truck came in and killed her after he left, and that was the cause of her death. It would have forced the jury to consider that intentional act, and it was reasonable and well-reasoned for the defense to ask in the charge conference not to give any instruction.
We have this all the time. You know, a defendant pursues a not guilty by reason of insanity defense, and hanging out there is a self-defense as well. And then there's an ineffective assistance counsel claim for failure to bring self-defense. I guess the problem you have in this case is he argued the self-defense, using my hypothetical. It may be one line, but he still argued it.
And again, I do agree that he mentioned it in passing, but I don't think that simply mentioning it entitled him to the instruction. And particularly here, even if it was ineffective, which, again, it's my position that Judge Chin did not abuse his discretion in finding it was not ineffective and that it was manifestly reasonable. It was not manifestly unreasonable when made. It would not have accomplished something better for the defense, where the jury found him guilty on murder in the first degree on two theories. They clearly found first-prong malice and intent to kill. They did convict him under premeditation. They also convicted him under extreme atrocity or cruelty, and there was overwhelming evidence to support both of those
Right,
theories.
but I mean, let's assume that they found that he smashed her head into the ground, as defense counsel argued. He's not guilty of first-degree murder if the jury has a reasonable doubt as to whether he was provoked to do so by her biting off a dime-sized piece of his penis, correct?
Well, I don't think it wasn't unreasonable for the defense counsel to try to avoid that, where he had to contend with the entire statement that there was no evidence of subjective.
But let's go back to your claim that the evidence is overwhelming as to deliberate premeditation and extreme atrocity or cruelty. If Again, let's assume that the jury plainly, from its verdict, found that he smashed her head into the ground, and that he intended to kill her he intended to kill her because he found him guilty of deliberate premeditation. If they had had that instruction, they also would have had to find beyond a reasonable doubt that he did not act in a heat of passion induced by sudden combat or from reasonable provocation. So if he was entitled to that instruction, how can we find that, because the evidence viewed in the light most favorable to the defendant warrants it, how can we find that it was harmless?
The appropriate standard is whether the decision when made was manifestly unreasonable, and it wasn't in light of the evidence that the defense presented at trial from an expert that there was another cause of death.
That's actually the trial judge's inquiry. Our inquiry is broader than that, to see whether or not the defendant got a fair trial.
Yes, and that was, it's, again, my position that the evidence does not support the voluntary manslaughter instruction. Times when this court has found that appropriate, there's been some evidence of subjective provocation. There needs to be a reasonable doubt on all four prongs of the provocation, and there was no evidence here of subjective.
As Mr. Keneally argued, not that Mr. Keneally, that Mr. Keneally. As Mr. Keneally argued, doesn't the Watson testimony satisfy the subjective prong?
Quite the opposite. The testimony from Mr. Watson is that the defendant said she fell down or passed out. And
Yes, if you parse, and your argument is we shouldn't parse the Watson testimony. He can't have his cake and eat it. So part of the Watson testimony is it was consensual sex, and my penis, she bit my penis, and the other part is there was no problems, right?
yes, and that it, not just that we can't parse it, but that it was reasonable for the attorney at the time to understand that he would have to contend with the entire statement.
Okay, thank you.
Thank you.
All persons having anything further to do before the Honorable Justices of the Supreme Judicial Court, now sitting in Boston, within and for the Commonwealth. At present departure, sitting of this court is now adjourned. God save the Commonwealth of Massachusetts. Court is adjourned. Thank you.